So here are the foundational facts of the case. On January 17th, the plaintiff served a temporary protection order on the defendant while the defendant was alive. The two parties have never met in real life, and in fact live in two completely different states, hundreds of miles away from each other. What that means is that everything in this case took place on social media, mostly YouTube, but also Facebook and Patreon. In her temporary protection order and application, the plaintiff claimed that the defendant admitted to stalking her for over a year. She said that the defendant obtained personal information about her and used a photo of her husband, who's private and not part of YouTube at all, in a YouTube video well before she ever interacted with the defendant. The plaintiff said that the defendant became fixated on her over the course of a year. She also said that the defendant had threatened to release personal medical information about her and had told multiple people that she was planning to travel to her state. The plaintiff also claimed that the defendant drove to a tire store and impersonated the plaintiff's close friend to get personal contact information about him. Because of all of this, the plaintiff felt compelled to show a picture of the defendant to her minor daughter to tell her not to open the door if she saw the defendant. There was a hearing set for a permanent protection order on January 24th in the plaintiff's state, but the hearing was continued because the plaintiff's lawyers said that more evidence and information had come to light and they wanted more time to prepare. So the hearing was continued until March 7th, which was last Monday. Between the time of January 17th, when the order was served, and the March 17th hearing, the defendant engaged in what the judge called a severe escalation of the harassment. So here's what the judge was referring to. Almost immediately after she was served the temporary protection order, which put in an injunction for her not to continue the behavior that she was displaying online, the defendant hosted multiple lengthy live streams talking about the case and the plaintiff in very threatening terms. In one live, the defendant talks about preparing to travel for the hearing, and at this point, the camera's off when she's starting to talk about traveling, but she then turns on the camera, holds up a Nerf machine gun, shoots it, and says, "Just practicing my aim." In another live, the defendant hosts a mock trial where she pretends to cross-examine the plaintiff on the stand. In this lengthy live, the defendant openly admits to extending the length of her lives to cost the plaintiff more money in legal fees. The defendant also discusses in various lives that she is going to subpoena the plaintiff's medical records as well as her husband and her minor child. In a later live stream, she talks about how the plaintiff filed a motion to quash the subpoena for her minor daughter, and the quash was immediately granted. What this means is that the subpoena was no longer valid and should not be served. However, the night before the March 7th hearing, when the defendant had traveled to the plaintiff's state to attend the hearing, the defendant compelled two of her friends, who she met on YouTube, to drive to the plaintiff's house with an intent to serve both subpoenas, even though the subpoena for her minor daughter was quashed. And, fun fact, spouses cannot be compelled to testify against each other, so neither subpoena was valid. It was also not being served in a timely manner. It was supposed to have been served for at least 48 hours before the hearing. Yet, this defendant YouTuber got two friends who she met on YouTube to break the court order and attempt to serve the subpoenas. Even if the subpoenas were valid, the defendant's friends didn't even do a proper service of the papers. They pasted the invalid subpoenas on the door of the plaintiff's house. The plaintiff and her family were home at the time, justifiably freaked out, and took photos of the entire incident, including the two subpoenas on the door. During the trial, the defendant was given multiple opportunities to accept a one-year protection order, but she declined to do so, knowing that if the judge finds against her, she will be permanently affected in a big way. And that's exactly what happened. A permanent protection order is a very big deal. It's a permanent part of your record. It bars you from holding certain lines of work, like working with minors. The defendant previously coached a girls' basketball team, and she'll never be able to do that again. She won't be able to coach her son's Little League. She also, this minor son that she has, it could affect her custody with him. And it's unclear to me at this moment, but I believe that she is also barred from owning a firearm. And she's openly and frequently voiced that she does hold a firearm for her protection. So it's possible she won't be able to do that anymore. Now, the defendant has indicated that she plans to appeal, and that may happen. But in all honesty, she's facing something even more ominous than a possible appeal. Because of her actions, which constitutes contempt of court, she may be facing criminal charges. And we know that the charges are being pressed by the plaintiff because her lawyer said so in court.